Okay, I'm live now, and Alexander Napolin here in Ontario, California. It's about 5:30 on Wednesday, and I have been sending out settlement demands and litigating files, and particularly dealing with insurance companies. So much fun, and I just have received a response from an insurance company today. I won't name the insurance company, but this one was a doozy. It was a response to a settlement demand that I placed with the insurance company. We're about a year away from the out from the accident on this hypothetical one here, and I receive a letter from an insurance carrier, and it looks like this right here. Just place it right there, and you can read it here. Take a moment. We'll just take a moment if you care to read it. And it just is so factually inconsistent. I just provided everything the insurance company could possibly have wanted to evaluate this claim appropriately, but they didn't. They just refused. It's a young woman, and she was in an automobile accident, and the police came to the scene and took a traffic collision report. Yet this letter in response to my settlement demand states that no, the police were not even called to the scene. Yet the police were called to the scene, and in fact, they took a police report and said they were called to the scene in that traffic collision report. The letter goes on to state some other things. It says that this person had back-to-back treatment dates along with several large gaps in treatment. Okay. Well, what does that mean anything? I presume when someone sends me a demand letter that they put facts in it, and that those facts should be meaningful to the evaluation, that you wouldn't put facts in a demand response or a counter demand that were irrelevant to your position. It would just be unnecessary. So I'm assuming they're devaluing her case because she had that, but this is a nurse. She's a registered nurse. And, in this particular circumstance, it was COVID, and she was a frontline worker and a student. She worked for a hospital in Los Angeles County. So she was quite busy. So she tried to get to her treatment best she could. Yes, she did. And then, going further here, the adjuster goes on to state that the findings on the MRI that I sent were normal for age-related degenerative changes. This person has a protrusion. It's not like just like a normal MRI. So it's just absolutely ridiculous that the adjuster would say that the MRI that was sent on this claim was normal. It's just not even probable. That it's completely factually inaccurate that it's normal. So I copied their insured on this correspondence, so I'm assuming their insured is understanding what kind of shenanigans are being pulled on the claimant. I don't know what they have to say about that. But anyway, it also goes on to say that the client's vehicle is minor with no frame damage, and that it indicates the damage to your client's vehicle is minor with no frame damage. This indicates a low speed impact, not likely to have caused injury. Now, this took place on a freeway, and the police reports has facts in it that this took place between 30 and 55 miles per hour on the freeway. So I don't know where low speed impact comes from and where you get that from, but this took place at 30 to 55 miles per hour on the freeway. I don't consider that to be low impact. Anyway, this is the type of stuff that goes on where I'm going throughout my day and I'm working my business, and I'm not having reasonable people on the other side when their insured causes an incident on the freeway. And, well, it's disheartening. That's why I'm ripping this company right now. But, you can't really, see who this is. So, this is all anonymous stuff. But, I would never go after anybody personally, because I'm hoping that I'll be able to send this letter now to the insurance company with some context and kind of point out that, hey, I sent you all this stuff and you should reevaluate this claim and make sure that it's treated with the correct facts, not with the incorrect facts. So if you're out there and you're wondering to get a lawyer or not, you're going to potentially face this type of issue. You don't know it yet, but you'll face this type of issue, and you're going to need to put everything together, and you're going to need to have someone to present it to the insurance company. So when I see these letters, it upsets me, and then we get to work on fixing the issue by placing another letter to the insurance carrier and saying, hey, that's not the way things are. And ultimately, it leads to litigation and a lawsuit, because the amount being offered to my client in this particular instance is just the claim's grossly undervalued, because the facts upon which the evaluation is based are grossly inaccurate. Just bad adjusting, and it happens. But I have noticed that some carriers, it does seem to be almost as if it's in the culture, in the similar ways that other other groups have cultural. The police, for example, they have a culture. Insurance companies also have a culture. And at some insurance companies, doing stuff that we just discussed in this video might be more happening than in other insurance companies, because they tend to be trained the same and be the same type of persuasion in terms of how they view claims and adjusting. So that's my rip today on insurance companies that just send completely bogus letters and undervalue claims. You do a lot better job, and that's what I'm doing, working every day to fight these types of injustices. So I'm going to sign off for now and see if I can do this, and I'll do another discussion later.